To the presentation for today. As Joy said, please don't hesitate to type any questions that you might have into the chat, as Joyce will be periodically checking that and letting me know what those questions are so we make sure to get those answered. So we'll dive right in here with the slides. So first and foremost, when it comes to estate planning, the primary consideration for most folks, or the number one thing that comes to mind, is really getting your assets to where you want them to go in the way that you want them to get there. But before we can even really start going through that analysis of the best way to make sure that happens, with all of my clients, I always kind of take a step back and start from the very beginning and say it's really more important first before we start chatting to understand what actually happens to your assets when you pass away. Because a lot of people will say things like, "Oh, I have a will, so that's going to cover everything," when not understanding that different assets are going to pass under the will or not under the will, or through probate or not through probate, and it's really all determined at its heart by how you own your assets. So this chart that I'm sharing here is the 4 different ways that you can own your assets, and you can see underneath each of those columns, different things will happen depending on which category your assets fall into. So the first column over on the left-hand side is for any assets that you own jointly between yourself and another person. And you see it's almost a straight line down to the bottom column of that page that says surviving co-owner. Because joint assets don't pass under wills, they don't go through probate. Instead, when you pass away, your ownership in that asset will transition automatically over to the surviving co-owner. So, for example, if you own your house jointly with your spouse, when you pass away, house goes to the spouse. There may be some paperwork you need to file in terms of just updating the land records, or similarly, if you have, joint bank accounts, you'll have to go down to the bank and provide a death certificate or maybe some other documentation to evidence the fact that one of the owners has passed. But the end of the day is the ownership transitioned over to you automatically, but there may just be some paperwork to evidence that fact. But the transition of the asset itself is really simple. Similar result for any assets that you have that are passing through a beneficiary designation, which is that second column. And some of the most common ones we see are listed off there, things like life insurance, retirement accounts, annuities. Pretty much any account that you have the ability to put a beneficiary designation on it. And with things like retirement accounts and life insurance, that's usually the default. So right from the moment you create those accounts, the plan provider, the bank, is automatically giving you that option to say, would you like to name a beneficiary? So to the extent that you have, and you've said, maybe it passes all to my spouse first, or if we're both passed, maybe it all goes to my kids second. Again, following that box in the column beneath it, you can see it's pretty much a straight line down to the bottom that shows those assets are going to pass directly to the named beneficiaries, again, without passing through probate, without passing under a will. So I kind of stop here when I'm going through this chart with all my clients to stress that fact that if your goal is to kind of keep things simple, get assets kind of the quickest and cleanest way possible to your intended beneficiaries, joint ownership and beneficiary designations are by far the simplest way to do that, because either one of those columns or a combination of both of those columns is going to ensure that those assets don't have to go through probate. But what does have to go through probate? And that's the third column there. Any assets that you own solely in your own name without a beneficiary designation on it. And at least in Connecticut, where I practice, the number one asset we tend to find falling into this third column is usually real estate. Just because with bank accounts, with life insurance policies, with retirement accounts, again, kind of all those financial accounts, even if they're solely in your own name, you can put a beneficiary designation on them and then they bypass probate. But at least in Connecticut, the state, at least the way the laws stand right now, they say we can't put a beneficiary designation on real estate. So even for, a married couple where the house was joint, okay, upon the first passing, or the passing of the first spouse, there wasn't any probate, but now after that death, there's just one spouse left and they solely own that house. So that's a very common situation that we see where there may have not been any probate that needed to be done upon the first death, because at that point everything was joint or everything had a beneficiary. But now after the first death, when the second spouse subsequently died, that surviving spouse had solely owned the house and maybe some of the bank accounts and other assets. So now all of a sudden probate's required, because it's those individually owned assets that have to go through probate when you pass away. Once we are already in probate, that's where the will comes in. because the sole purpose of the will is to be kind of the instruction manual for the probate court for where those assets are supposed to go. My house goes to my spouse, or these assets go to my kids, or this goes, to somebody else. That's where all those instructions are going to be. As part of that probate process, I'm not sure how many people have had or have had to go through that process. And even though I know I'm practicing in Connecticut, most of the states I've dealt with in New England and surrounding areas tend to have a pretty similar process in terms of what probate requires. And kind of as evidenced by all these little boxes here in this third column, it's a lot of steps. There's various filings that are required at different stages. There's even waiting periods before we can proceed and file additional forms. A lot of times the courts are also fairly backlogged, so even if we're submitting something, it doesn't get processed right away, which is why the number one complaint I've heard from almost anybody who knows anything about probate is just that it takes a really long time. So that's why probate probably gets as bad of a reputation as it has, is the timing piece of it. But at the end of the day, probate's just there to make sure the assets get to where they're supposed to go. So you'll see the very bottom box in that third column does say, once we get through all the required steps, the last step is the assets do get distributed out to the beneficiaries that are named under the will. But again, it just takes a little while before you're ultimately going to get that result. The fourth column on the end here is for a revocable trust. Sometimes they're referred to as living trusts. But I'm going to be going into a little bit more detail about what trusts do and kind of the different types of trusts that there are a little bit later in my presentation. But kind of the big takeaway, just for purposes of this chart, is that assets owned in trust get to bypass probate. So a bank account or a house or any other asset you have titled into a trust at the time you're passing bypasses the probate process. And then the trust will say, kind of similar instructions to the will. When I pass away, this asset goes here, this asset goes there. So it has that same set of instructions for the distribution of your assets, but that distribution or those distributions just get to happen much quicker because there's no probate court involvement required.
So, Allison, I have a question.
Okay.
If you go back to, okay, so if I were to, if my one of my horses is joint owned with somebody else and something happens to me, would it automatically go to that person?
Yes. So
Okay.
that's where joint ownership is such a wonderful way to make things simpler. Because otherwise, as silly as it sounds, we may have to go through probate just. Oh, I think I got muted there for a second.
I'm sorry, I was trying to mute somebody else and I inadvertently muted you. My apologies.
No, no problem. So I'll just say the simple answer is yes. If your ownership of your horse is titled jointly, it bypasses probate.
Thank you.
All right. So next, just to get into a little bit more detail of what probate actually entails. So again, the number one reason why probate exists is just to ensure your assets get to where you said you want them to go. So it also is going to provide, so yes, the court's going to have oversight, make sure all the assets are distributed appropriately. The court is also going to provide kind of the legal paper trail that shows ownership of your assets have transitioned over to someone else. So even if you have a will that says, when I pass away, my house goes to my husband and my horse goes to, my friend, John Smith. Yes, those are your wishes, but simply having it written in the will doesn't actually transition ownership of those assets to those people. You need the court to kind of officially approve those distribution instructions and then issue a decree or a certificate of devise, basically some paperwork that shows the transition has actually happened. So that way, the person you've left the asset to can then have that in hand to say, yes, I am now the owner of the horse, I am the owner of the house. So probate is so vital just for that, getting that paper trail. The downside to probate, aside from the kind of the timing aspect, which is the bottom. Actually, maybe I'll jump down to that first. So the bottom bullet on this page, probate does take a long time. So there are different types of probate processes depending on the amount of assets going through probate. So again, just in Connecticut here, if the assets that are going through probate are valued at $40,000 or less, there's a small estate procedure where, yes, some forms need to be filed, and we do still need the court to approve distributions as the will instructs. But because it's kind of a smaller value of assets going through that process, essentially the court lets us prepare all the paperwork that we need, submit it all at once, and then once the court processes it, we're done. So the process can it may be only like 2 or 3 months, and the longest piece of that is just waiting for the court to approve the paperwork. But if the total value of assets going through probate is over 40,000, or if there's any type of real estate involved, that's when we have to do what's called a full administration, which easily takes a year, if not longer. And a lot of times we can go over that 12-month estimated timeline if there's really complicated assets passing through probate, or just a lot of assets passing through probate. If the courts are particularly busy and backlogged, it could take longer. If there are people who have objections or are having, hiring lawyers and fighting amongst themselves, that will draw out the length of the process too. So in general, I mean, probate's already a pretty lengthy process to start with, but those timelines can even be prolonged depending on the complexity of the estate. And going back to kind of that second bullet point there, the probate process is also public. So believe it or not, you can go into your local probate court and say, oh, my neighbor, Kim Smith passed away 6 months ago. I'm really interested to see what her will says. And you can go in, ask for a copy, and they will give it to you for a couple of dollars, along with a bunch of other documents, if you're so inclined, that were filed in that estate that show here's the assets she actually had, and here's how she said she wanted it to be distributed. So that's another potential downside to the probate process, is that to some extent you're airing your dirty laundry in public and anybody can find out about it. All right. So coming back to will, so if we are going through probate, your will is your instruction manual, as I call it before, for the probate court, saying how you want your assets distributed. And remember, if you have a will that says, here's where my assets are distributed, but all of your assets are jointly owned or beneficiary designated, just keep in mind that those joint assets, those beneficiary designated assets, don't even pass under the will, because they have to be individually owned assets first in order for the will to apply. But if we do have individually owned assets or probate assets, the will say where they want them to go. The will also says if I have minor children, I appoint, my parents or my siblings or whoever might be as guardian for minor children. Similar for pets, or specifically your horses, you can specifically say, here's who I want to be kind of essentially a guardian, just like with the minor kids, or who's going to be taking care of my horse. And also, the will is going to have the appointment of the executor, and the executor's sole job is just to be that person that files any necessary documents with the probate court. And I know I've kind of said this several times, but I'm going to say it one more time. Probate avoidance is not bad, but by no means is it where we want to end up. Every single client who walks in my door typically says something along the lines of, I want my estate to be easy for those I leave behind. I want it to be simple. I don't want to have my beneficiaries or my heirs have to go through a bunch of paperwork after I pass. So that all boils down to, let's keep as many things out of the probate process as we can, because probate is a lot of things, but simple is just really not one of them. Oh, and I apologize that there seems to be a little bit of formatting issue here, but so what if you have assets going through probate, but there is no will? Your joint assets, as I mentioned, will still pass to your joint owners. Your beneficiary designated assets will still pass to your named beneficiaries, and those individually owned assets still have to go through probate. So none of that has changed. It's just now that there's no instruction manual for the court, the state has a set of default rules called the laws of intestacy. And the good news is, there's no state out there that I'm aware of that the default rule is the assets go to the state. So I know that's a common misconception. If I don't have a will, it all goes to the governor's mansion. Nope, the state doesn't get to keep your stuff. They have these laws of intestacy, as I mentioned, and kind of the simplest and very high level overview is that it goes to your closest living relatives. And that's what this chart here is, a summary of what the intestacy laws are here in Connecticut. And this may vary from state to state, just because each state legislature can come up with their own rules. But in Connecticut, if you have kids and you don't have a spouse, all goes to the kids. Okay, so far so good. If you have a spouse and no kids and no parents, it all goes to your spouse. Again, probably pretty close to what people would want. if you have a spouse and children, and the children are both the biological children of you and your spouse, then the spouse gets the first $100,000, and then the balance gets split 50-50 between your spouse and the kids. So here's where maybe it starts to get a little tricky, because I've seen situations where the net end result of this is that in some way the spouse actually ends up joint owning the home with their minor children. So, I mean, imagine owning a house with your 10-year-old. Probably not what you would have wanted. And there's all these other different scenarios that are evidenced on the chart here. But I think the simple answer is you never want to rely on the default rules because it may work out okay, but maybe not. And there's even a bigger chance of it not working out okay if you have really specific wishes for where specific assets go. Such as, well, even if I'm married, maybe I still don't want all of my assets going directly to my spouse. Maybe I have children from our first marriage that I would want some kind of division between my spouse and my kids. Or I specifically would want my horse to go to, my business partner, my best friend who has experience in owning and caring for horses, things like that. So when you're thinking about doing estate planning, and sometimes people say, maybe I don't really need to, I would say at a bare minimum, having just a really simple will, laying out your instructions for where assets are going to go, just in case you do have assets passing through probate, is a really good idea. All right, so wills are one way to provide instructions for where your assets go. Another way to do that is with trusts. So as I mentioned, trusts simply, one of the biggest benefit for any type of trust that you have is trust-owned assets get to bypass probate. But trusts are kind of like Baskin Robbins. There's 31 different flavors. So depending on the specific type of trust you have, it may function a little bit differently because it's intended to do something specific, where another trust is intended to do something else. The three types of trusts that I'm going to be talking about in my presentation today are testamentary trusts, revocable trust, or again, also sometimes known as living trusts, and irrevocable trusts. Before I dive into my discussion on trust, I always find it's helpful just to do a little terminology lesson here. So, number one, the settlor, sometimes also called the grantor, sometimes called the donor, it's the person who created the trust. So you want to create a trust for estate planning purposes. You are the settlor of your trust. Then there's the trustee. The trustee is the person in charge of the trust. So, because these trusts are going to own assets, we need to have rules for how the assets can be managed, what's supposed to be done while this trust is in place and there's assets in there. But that also means we have to have someone in charge to make sure those rules are being implemented or what needs to get done actually gets done. And so that's the trustee's job. Last but not least, and this is probably one that everybody knows, but the beneficiary. Who is the trust for the benefit for? And a lot of times with some of these trusts, it's not uncommon for one person to be filling multiple of these kind of roles. So specifically with revocable trusts, now I'll probably mention this a little bit later, it is not uncommon for you to be the settlor and the trustee and the beneficiary. So just because you're serving maybe in one of these roles doesn't mean you can't be in another. All right, so testamentary trusts. A testamentary trust is a trust that's actually in the will itself. So I know so far I've been describing wills and trusts as separate, and I mean they really are, but from a document standpoint, the trust can contain a will. So while the will says, here's where my probate assets go, the will can also say, and then I want to create a trust to hold assets going forward. Um, and with this testamentary trust, you can say who the beneficiary of the trust is going to be. So to maybe give you a very common example, I have a younger kids. So in my will, I could say, well, when I pass away, I want all my assets. If my husband's predeceased me, all my assets go to my kids. But gosh, I mean, they're really little. So, and heck, even if they're 18, I don't really feel comfortable having them inherit a bunch of assets if something bad happens and they get everything that I own. So I can say, well, I really would feel more comfortable if they didn't inherit assets until they were at least 21, 25, some age a little bit higher, hopefully a little bit more mature. So my will in that instance would say, I give everything to my kids unless they're under the age of 25, in which case I have created this testamentary trust that will instead receive the assets for them. And that trust will say how the assets can be spent for them. It will say who I've appointed as trustee to make sure those rules that I've written are implemented. And when I say things like, I want my trustee to make distributions to my kids, maybe at certain ages, um, again, that the trustee is going to make sure all those distributions happen. It's also going to say when this trust can go away. So, as I mentioned kind of before, in my example, I would feel more comfortable if my kids were at least 25 before they get the assets. So, even if I pass away, they're little, this trust is going to be created. It'll be around until the kids turn 25, and then the trust can terminate, and then they will receive their assets outright. I also am a big fan of including alternates. So, I can say, well, yes, it goes to my kids, but oh, God forbid, one of my kids has passed away after this trust was created for them. Where does it go next? And it can say things like, well, if they have kids, it goes to their kids. Or if I don't have kids, or if they don't have kids, it goes to my surviving children. So you can include all those alternates. And similarly, you can do the same thing with a trustee. So it's not uncommon for me to work with clients and say, well, gosh, even 21, 30, those ages sound kind of young, or my kids are in their 20s and they're just really not capable of managing money. Maybe I want this to be a lifetime trust. So this trust could theoretically be around for another, 20, 30 years. So in that case, it really makes sense to include not only alternate beneficiaries, but alternate trustees. Because if this trust is in place for a really long time, you're going to want to have all those backups in place. It's important to note that a testamentary trust is only formed or really only comes into existence after the will is submitted to the court. So the trust really, again, isn't created during your lifetime, which means you don't have the ability to what we call fund the trust during your lifetime, actually transfer ownership of any assets to the trust itself. So there's no probate avoidance. So the assets would still need to, even though it's a trust, and I know on my initial chart there was a separate column for the revocable living trust that says, yes, you get to bypass probate, but that specifically does not apply to the testamentary trust because the testamentary trust is contained within the will. And if we're looking at the will, remember that means we're already in the probate court. Also, too, because this is passing through the probate court, that means to some extent the trust is formed in the probate court and through or under the probate court's supervision, and so it has to continue to stay there. So if I have this testamentary trust for my kids that says, okay, it's going to be around until they're 25, even after my estate is all settled, the probate is all done, there continues to be a probate court file or probate court matter for the trust itself. And every year or every 3 years or so, the trustee has to continue to report to the court and file accountings to prove what they're doing with the money, which also gives the beneficiaries right to request information, or if there's any disputes, the court can kind of mediate those disputes. But just suffice to say that with these testamentary trusts, once you're in probate court, you really have to stay there for the entire duration of the trust. Next is the revocable trust. So this was the one that I had on that initial flow chart. And a revocable trust comes into creation. It's formed during your lifetime. And also, too, maybe I work a lot better when I can picture what I'm talking about. So whenever I talk about trusts, I always think of a bucket because that's really what a trust is. It's kind of a legal bucket that you can put your assets into. So with this revocable trust, we form your bucket during your lifetime, and you can transfer assets actually into your bucket during your life. So one of the hypotheticals I had given when I was going through the chart is to say, okay, well, my spouse has passed away. I solely own my house. That means if I keep it that way, when I pass away, I know my kids or my beneficiaries are going to have to go through probate because I solely own the house. And I would really like to avoid that. So I create a revocable trust. I do a deed and I transfer ownership of my house into the trust. So the trust itself owns my house. So that way, when I pass away, the probate court says, I didn't own my house. The trust owns the house. So it gets to bypass that whole probate process. So you have the option like that to transfer assets during your lifetime into the trust. You can also set up the trust to receive assets only upon your death. So this is a combination of thinking back to the flow chart, the second and the fourth columns. So that's the beneficiary designated asset column and the trust column. So I have, let's say, a life insurance policy, I have an IRA, and I filled out those beneficiary designation forms to say, okay, if I pass, it goes to my trust as the beneficiary. So during my lifetime, I am still in control of those accounts. I can still do as I please with those assets. But then when I pass away, instead of passing directly to one of my young kids, who I said I just didn't want to get that money, I have it passed directly to this trust that I have established that says, again, it has those rules to say if they're under a certain age, nope, it's really managed for them. So when you have trust, it's not only the ability to place assets into the trust now, but again, you can also have the trust just kind of there and waiting to receive assets like life insurance or retirement accounts or investment accounts after you pass away through a beneficiary designation. During your lifetime, you are in total control of your revocable trust. So, this is where I mentioned when I was going through the terminology that it is very common with these types of trusts that you are the settlor, the trustee, and the beneficiary. It is all you. Because the purpose of these trusts is not to separate you from ownership and control of your assets. It's simply just to make sure the assets don't have to go through probate when you pass away. But if your house is in trust and you want to sell your house or refinance it, we still want you to be able to do that. So that's why these trusts say during your lifetime, you still have full access and control over the assets in those trusts. Just as with the testamentary trust, you're still going to say, and then when I pass away, here's who my beneficiaries are. Here's how it's, if the trust is going to continue on, like I've been using the example of my young kids. Here's the rules for how their inheritance is to be managed. Here's when they can receive distributions. Here's who the trustees are going to be. All of that is still the same. Um, and then again, as I've stressed, but I'll stress one more time, assets owned in the trust do not need to go through that probate process, which is the number one reason that people create these trusts. The one thing these trusts, these revocable trusts, do not do is they do not protect your assets from creditors. And the number one creditor that a lot of times we're looking at in estate planning context is, God forbid, I need a skilled nursing facility. I need 24/7 caregivers coming into my house. As I'm sure it's not hard to imagine, or maybe some of you have seen firsthand, that type of care can be really, really expensive. So if we're worried about not only protecting your assets from going through probate, but we say, man, I would really like to protect my assets from having to be sold on that care. I want to make sure there are actually assets left to pass behind or pass along to my kids or to pass along with my horse to help pay for its care. The revocable trust can't guarantee you that. Because the revocable trust, remember again, lets you stay in total control of your assets. So you have full access to go into the trust and get those funds that are in there, which is why there's no protection because your creditors can say, just go into your trust and get your money because the trust lets you do that.
Allison, we have a comment question on the testamentary trusts.
Sure.
Probate will also charge a fee for each filing. Is that correct?
So that's going to vary from state to state, but I'll give you a very lawyerly answer. It depends. For standard filings that are required in each and every estate, there isn't a separate fee for a lot of those filings because there's maybe an initial fee to open the estate, but then after that, those subsequent filings don't require a fee. But if there's something unique coming into the estate where I want to specifically request permission from the court to do something that's not authorized under the will, there might be a separate filing for things like that. So it kind of depends on what you're filing. All right. Was that it for questions, Joyce?
Yeah, that came from the audience, so I think so.
Okay. All right. Thank you. All right. So now we've gone over testamentary trusts, we've gone over revocable trusts. Now we have irrevocable trusts. So these are the type of trusts that do provide protection from creditors, specifically like protecting assets from potential future long-term care costs. Um, the difference between revocable and irrevocable trusts is kind of right in the name. The irrevocable trusts are irrevocable. Once you put them in place, you don't get to rewrite the rules. You can never amend it. You can never revoke it. The intent is that once assets go into that trust, you're never able to get them back. Um, but that's very intentional because we specifically don't want to allow you access to those assets because that's how we're going to get that protection that we're seeking. With these irrevocable trusts, You'll always be the settlor because you're always the person that's going to be creating these documents. But it's highly unlikely that you're going to be the trustee or the beneficiary because as I mentioned before, we want you to lose control. We want you to lose access to those assets because if you can't access those assets, neither can your creditors. Because as I mentioned, long-term care costs is one of the number one reasons these days that we're implementing these types of irrevocable trusts. Really, what that means when I say long-term care costs, it essentially means we're worried about a potential Medicaid application. So I know Medicaid is a very broad federal program. It does a lot of things, but one of the number one things it does for individuals over age 65 is it can pay for long-term care costs. So if I need to go into a skilled nursing facility and I run out of money, I tried paying for my care costs for a while, but just because it's so expensive, I'm out of funds. I can now apply to the state's Medicaid program, and they will then pick up the tab for 100% of my skilled nursing care costs or potentially even in-home care once I'm deemed to be eligible. But the number one eligibility requirement for Medicaid is you gotta have no money or pretty close to no money. So specifically in Connecticut, they say to be eligible for Medicaid, you can only have $1,600 to your name. So again, not zero, but not very much at all. But then the other catch along with that Medicaid eligibility is they also have a 5-year look back. So again, even though Medicaid is a federal program, it's administered by the states. So each state may have slightly different rules. So what I'm going through here are specifically the rules in Connecticut. But every state, again, that I've kind of brushed up against and looking at these type of long-term care questions, there is some form of look back period. So in Connecticut, it's a 5-year look back. And what that means is to say that, okay, I've run out of money. I submit my Medicaid application to the state and they agree and they say, yep, after doing a review, we've determined you are below 1600, but how did you get there? How did you get rid of your money or how did your assets get spent down? And if they see within 5 years leading up to the date of my application, I gave away my assets, then they're going to say that's a disqualifying transfer. That's a kind of a disqualifying gift. So I'm not actually eligible for Medicaid. So when we're trying to do this, coming back to the irrevocable trust, if we're trying to do more what we call asset protection planning, trying to protect my assets from nursing homes and caregivers or any other creditors I might have, I can transfer my assets into an irrevocable trust, but the state says, remember, again, that's a gift. So now I have to cross my fingers and hope I don't need a Medicaid application within the 5 years of the date of that transfer, or else I'm going to potentially be deemed ineligible for Medicaid benefits because I've violated that 5-year look back. If I gift my horse or money or my house 6 years ago and I'm now applying for Medicaid, I'm fine. We just have to get outside of that look back period, which is why if I'm even having these type of conversations with clients about do we want to protect assets, kind of the first question is, well, is it realistic that we're going to be able to go 5 years before submitting a Medicaid application? Because if we know right off the bat that I already need care. So we're kind of already in that process, and I do not have the ability to pay for it for the next 5 years. We may have already taken irrevocable trust off the table as an option because we know right off the bat we're not going to be able to get outside that look back period. So if you're considering anything like an irrevocable trust, I always say speak with not just maybe an estate planning attorney, because not all estate planning attorneys necessarily specialize in more what we call elder law or this Medicaid eligibility side of things. So I would always speak with an elder law attorney to walk through, is this a type of trust that makes sense for you? If yes, do we think we're going to have a problem with a look back period? Because if we just go ahead and implement this irrevocable trust, remember it's irrevocable, it's hard to undo. Sometimes we can kind of build in a little bit of flexibility and find a way to undo it if we need to. But again, you don't want to kind of put something in place right off the bat to know that, or come to find out 5, 6 months later, you just have to undo it all because it didn't make sense. So you should really be talking to an elder law attorney to figure out if this is something that would work for you before you go and implement it. All right, so having now talked through all the different types of trusts, wills, and the kind of the documents that you can use to make sure your assets get to where you want them to go, how do you specifically address your horses in your estate plan? So really simple, really easy, you can just make an outright bequest. Again, whether it's in the will, whether you have a trust. And it says, and I give some examples here. So I leave my beloved horse Seabiscuit to my friend John Smith. Period. End of story. You can also have the bequest accompany with a cash bequest too, to say that, well, yes, I want to leave my horse to my friend, but there's going to need to be a sufficient fund there to pay for, veterinary bills, for lodging, for anything else my horse might need. So I not only leave my beloved horse Seabiscuit to my friend John Smith, but I leave it along with the sum of $15,000 also to John Smith with the intent that the cash be used for the horse's care. Kind of a twist on that is to say, yes, I want to leave my horse and $50,000 or $100,000. I mean, whatever that cash amount might be, but maybe I just want to put some safeguards in place to make sure the person I'm leaving this money to is really doing the right things with it. So I can, instead of just saying, okay, John Smith, here's my horse and here's a check for $50,000. Okay, my horse goes to John Smith, and then I create a trust for my horse with the $50,000. And now we go back to the same exact rules we were reviewing before with, all the other different types of trust, the revocable trust, the testamentary trust, the irrevocable trust. They all say, well, here's who the trustee of the trust is going to be to make sure the money is being spent appropriately. Maybe it's John Smith himself, or maybe you say the whole reason I have this is to kind of put some safeguards in place. So maybe it's my friend Jane Smith that's managing the money, even though John Smith is handling the day-to-day care to put some kind of checks and balances in place. Um, so, I mean, you can set it up simply with just saying, here's the cash, or here's the horse, or here's my horse, excuse me, or you can go with more of a trust format. It really boils down to what makes you feel most comfortable. But a lot of times I say if there's a fairly large cash bequest going along with the animal, I like the idea of a trust just because the people that you're leaving this money to may be very trustworthy, but it is also very tempting when somebody gives you a $50,000 or $100,000 check to do some things with it that maybe you hadn't intended. So depending on the size of the bequest, or I should say maybe just the larger the bequest, the more I might recommend considering a trust versus just an outright distribution. Also, too, if you go with the trust, or even quite frankly, if you just do the outright bequest to say, my horse goes to John Smith, you can get fairly specific in terms of what you want the money to be used for or how you want the horse to be cared for, even if you're not leaving a cash bequest. A lot of it's what I call sometimes precatory language. It's not necessarily legally binding, but you say, it's my fondest wish, it's my sincerest hope that my horse be able to remain at the same stable with the same people, that they continue to receive veterinary care from the same vet. So if you have like these specific type of instructions, you can always include that in the document. Again, just being mindful of some of those instructions can be enforceable. So things like the money is only to be used for veterinary bills, lodging, food, things like that. That's an enforceable bequest. But you can't mandate that my horse can't be moved to, a different barn or a different state, because situations like that something might arise that was unanticipated. Maybe that stable or where the horse was staying or being boarded is no longer there. So the horse may have to be moved. So just being mindful that we can't necessarily mandate all of your wishes to make sure they're actually fulfilled, or even kind of things that are more, I'll call them iffy, things like I would really still love for my kids to be able to visit and ride the horse on Thursdays after school. Again, we can't mandate those types of things, but I do find that language is really helpful to the person that you've left the horse to care for, because assuming you've chosen them for a reason that they really want to do what you would want them to do, the more instructions you can give them, the better off it is going to be, not only for your peace of mind, but for them not having to guess, well, gosh, what would they have wanted me to do? Because you've already provided those instructions for them.
Allison, we have two questions.
Sure.
First one is, can you continue to fund an irrevocable trust after it has been created?
hmm So yes, once your irrevocable trust, so remember, kind of picture your trust bucket again is created from the moment you've signed it. Yes, so at any point you can add additional assets to the trust. But just being mindful again, once those assets go in, they don't come back out again. And also, too, if we're looking at this from an asset protection, again, really, if we're looking at this from protection from Medicare, Medicaid, and we're worried about the 5-year look back, each time we make a gift in, that's now we've started a new 5-year clock that we need to outrun. So in 2020, I created my irrevocable trust and I put $10,000 in there. Now in 2026, I put another $10,000 in there. Okay, so I've run past my clock that I created when I did the initial 10,000 transfer in 2020, but now in 2026, I've just started a brand new clock because I've made a brand new gift. So just be mindful of that.
And my specific question on the next page is, so where would you specify this in your will, in either of those types of trusts?
So it can be made in either. So I think initially you start from just a more general estate planning review to figure out, is probate avoidance, for example, really important to me? If yes, then we're probably setting up a revocable trust to really have the instructions for how your assets are supposed to be distributed, because the goal is we want to avoid probate. So we want to kind of not have to use the will as much as we can. So in that case, the instructions would go in the trust. If we say, well, I don't really care if I have assets going through probate, I've actually had people look at me and say, well, I'm going to be dead, so it's not my problem. Um, if that's the case and probate avoidance, again, isn't an issue, and you kind of just say, I just want a simple plan in place with what I want done, then it would go in the will. All right. Any other questions?
Not yet. Thank you.
Okay. All right. So far we've been focusing on, as most estate plans do, we focus on, well, what happens if you pass away? Because that's the number one reason we typically implement an estate plan, is to have instructions for what happens after you pass. But any good comprehensive estate plan, oh gosh, and I'm skipping ahead, so sorry. And I apologize too. I promised when I set up my presentation on my screen, I didn't have overlap in the heading, so my apologies here. But some final comments on including your horses in your estate plan. Always include alternates. And I know I've kind of touched on this before, but I'll just say it one more time. Include alternates for the trustee, because we don't know how long these trusts are going to need to be in place. I mean, I hope I don't pass away in the next couple of years, but if I do, my kids are, under the age of 10. So if I have a trust until they're 25, that's 15 years that this trust is going to need to be in place. So to have alternate trustees is good. Alternates for the people who are handling the day-to-day, specifically again for your horse. So yes, I initially said to John Smith, but John Smith is my age. And if I've passed away, what are the odds are that he's also maybe older or has some health issues or might have passed away himself? So even if he's able to start caring for, and initially after you pass away, start being that caretaker for your horse, include an alternate to say, but again, but if he can't do it at any point, here's who's next. And also for your horse itself. So if your horse predeceases you, so this is a will or a trust that you've set up quite a long time ago, and since you've set that up, your horse is now passed. In that case, would you want to say, well, if I have another horse, then these same provisions apply to that horse? And if I don't have a horse, maybe it goes here next, and it goes to, our charitable organization, or it passes to other friends and family members. So think about alternate really beneficiaries in that case. Also, too, if you don't have somebody specific in mind for, this is in my example, I keep saying, John Smith will care for my horse. Well, what if I don't have a John Smith? What if I can't really think of anybody who would be willing or able to take on my horse and take care of them? Well, one, you may be surprised at some of the people that are close to you may be willing to take that on. So, I mean, start having those conversations with your friends or your family members who you think might be interested and may be able to take that on. But if the answer is none of those people are really going to be able to step in and help, research nonprofit organizations. So there might be some organizations, and I guarantee you there probably are, that already exist specifically for this reason. They can step in, they can take care of your horse. And that's why also too, if you are including one of these nonprofits, I would even go back and reconsider the cash bequest piece of it, because a lot of these places may be running on, a kind of a shoestring budget. So the more funds you leave behind for your horse, you can probably guarantee the horse is going to receive the care that you would really want them to receive. Also consider what happens if your horse should pass away after, you've put all these plans in place for them. So you've made this trust for your horse, and it says, for all these things to happen, and then 5 years later, your horse passes. Are there any specific instructions you would have, not only for if there's remaining funds, where would those assets go, which I mean, you should definitely include in there, but in addition, things like, well, I would like my horse to be cremated in his ashes, maybe buried in the same burial plot as me, or scattered, in the Adirondack Mountains, at the top of a beautiful mountain somewhere. Think about what you might want to have happen there. And I mean, if you don't have anything specific, you don't have to include those instructions. But if you do have really strong wishes for like what you would like to see happen, it definitely should be written into the documents. All right. So,
Allison, I'm sorry.
okay, no, go ahead.
We have another question about irrevocable trusts. Um,
Okay.
if you're putting more into one of those trusts, is that done with actual funds and with your lawyer?
So this is where I get to say again, kind of, it depends. If you can fund these types of trusts with whatever you want, it just comes down to, well, what are you trying to protect? Because once that's the whole point of these trusts. I want to try to protect a specific asset or specific group of assets so they don't have to be, attacked by my long-term care costs, or if I get in a car accident and get sued, I know they're protected and can't be touched. One of the most common assets we tend to do this type of planning with is real estate. So if all else fails and I have to spend all my money on my care, at the very least, my house would be protected, and that can pass along to my kids. Or at the very least, the ownership of my horse and again, money for its care is kind of protected and set aside. But at least talking about real estate, at least in Connecticut, lawyers typically prepare the deed that's going to say I convey my house to the trust, and that gets recorded on the land record. So more likely than not, you're working with an attorney for that transaction. But if it's, I just want to transfer, I have this bank account and I want to put the bank account into the trust, your lawyer has set up your trust for you, but then you can go down to the bank and give the bank, here's a copy of the trust. I want to transfer X amount of dollars into my trust. And then you could coordinate that directly with the bank or the financial institution that you're working with. All right. So now coming back to kind of the final thing I just wanted to address during the presentation is incapacity planning. So kind of what I had hinted at before, is a lot of this has been focused so far on planning for after my demise, what's going to happen to my horse, to my assets. But I mean, things could happen to you and you might not pass away. A lot of my clients, as they're living longer these days, are being diagnosed with Alzheimer's, with dementia, or even things like Parkinson's and cancer. And so they may have a fairly long lifespan, but they may not have capacity to do all the things for themselves that they normally do. So any good estate plan should not only have things like a will or potentially a trust, but it should also have documents like powers of attorney, healthcare directives, or some states call them healthcare proxies, living wills, HIPAA waivers. All these things are not only gonna are more towards the side of not if you've passed away, but again, I become incapacitated or some way, shape, or form during my lifetime. But I know my affairs can still be handled, and I've chosen who the people are that are going to make those decisions for me. So the power of attorney is all about the money. So that is the person you appoint to be able to stand in your shoes and access your bank accounts so they can pay your bills, they can sign your checks. If ultimately your house does need to be sold because you have to transition into assisted living or skilled nursing, they can sell your house for you. They can file your taxes. They can re-register your car with a DMV. Kind of anything and everything related to your assets. That's going to be the job of the power of attorney to handle those matters. Keeping in mind that there's two primary types of powers of attorney. I'll just call it kind of the default or standard power of attorney is effective right away. So even though I'm perfectly competent, I can manage my affairs, I've said my husband can do handle all my financial matters, and if he can't do it, then my sister is next. So because I've appointed my husband as my my person under the power of attorney, I can even be, let's say I'm on a trip down to Florida, and we just happen to be refinancing our house that week. He can sign all the bank paperwork on my behalf, even though I'm completely competent, but I've appointed him to be able to manage my affairs. So it's not dependent upon me being actually incapacitated before he can act. There is a separate type of power of attorney which is contingent upon me being incapacitated, and that's called a springing power of attorney. So it only springs into effectiveness, and the person I've appointed really can only start acting for me when I actually am incapacitated. And that's usually accompanied with that person has to get some type of written evidence from a doctor proving your incapacity. A lot of times they'll also have to sign a separate affidavit to say, yes, I've gotten the medical evidence to say they're incapacitated, so now I can act, and that has to be witnessed and notarized. So there's kind of some additional safeguards in place to ensure that person is only really acting when you need them to act. So just being aware that when you say, okay, maybe I want a power of attorney, you also get to choose kind of when you want that power of attorney to be effective. Next is the healthcare directive, which is really, or as I mentioned, I called it before, healthcare proxy. This is the medical power of attorney. So if I can't communicate my wishes to the doctors in terms of, do we want to do a certain type of medication? Should I have a certain surgery? The person I've appointed under my healthcare directive can make those decisions on my behalf. Kind of to go hand in hand with this is a living will. And despite its name, it doesn't have anything to do with probate or distribution of your assets. The sole reason that the living will exists is to provide instructions for the withholding or receipt of medical care at end of life. So some of my pretty blunt clients call this the pull the plug language. It states that if I'm really in an end of life situation, so the two legal triggers in Connecticut that I would have to meet for the living will to apply would be I either need to be terminally ill or I need to be permanently unconscious. So if I meet either one or both of those thresholds, then I don't want artificial means of hydration or nutrition. I don't want artificial means of respiration. I don't want CPR. So to kind of don't do all the heroics if it's really not going to do anything to prolong or to make me better. It's really just to keep me alive at that point. I don't want that. The HIPAA waiver is the last one here on the slide. And unlike these other documents, a HIPAA waiver doesn't authorize someone to make decisions for you. A HIPAA waiver is just access to information. So I know a lot of folks, I mean, every time you go into the doctor, the dentist, they always have you sign these HIPAA waiver forms. And for the most part, it's kind of, they have a blanket one that just says, we want to be able to release your information. And a lot of times it's to your insurance company so they can submit a claim, maybe to refer you to another doctor, things like that. But this HIPAA waiver is more specific to I want my doctors to be able to talk to my spouse and my sister. So if they call up, they can gain access to my medical information. A lot of times, folks do have this filled out directly with your doctors because every time you go in and they say, okay, we'll check, is this still your address? Is this still your phone number? Typically, there's a box somewhere down the bottom of that form that says, but can we call anybody else? Can we leave a message with someone? Be mindful that's a HIPAA waiver. So yes, we do offer, at least in my office, we can prepare a separate actual paper form as kind of just a blanket form for those people to take with them if you're someplace where they don't have your records on file. But if it's your primary care doctor, they might already be named if you've already given them that information. All right, so that's kind of the end of my presentation. So I will open up the floor to see if anybody has any questions about anything I've gone over, or maybe just some related questions in the last 5 minutes here that maybe is a topic I haven't touched on.
So Allison, I have a question.
Sure.
So I I have a couple of horses. I have told my kids what I want done with them and for their care if something should happen to me, but it's not documented in a will or either one of these trusts. Is it valid? Are they authorized to carry out my wishes without any legal aspect of this whole thing?
So, and again, I know I keep repeating this, but it depends.
Okay.
Um, so let's just say if you have a will at least that says, well, if I pass away, everything I own goes to my kids.
Ah,
So the end result is, yes, they may have to go through probate, but they'll get your bank accounts and they will have ownership to your horse. So at the end of the day, they own everything. And since you've already talked to them and said, this is what I'd like to see happen, they can then voluntarily go and implement your wishes because they know what to do. So, I mean, that's a really simple way to do all this planning. I know I've been talking about trust and kind of writing up all your instructions, but that's kind of the lawyer in me liking to have those safeguards, liking to have it in writing. But as long as you've made your wishes clear and ultimately all of your assets are passing to the people that are going to be carrying out those wishes, it can still work, even though it's not in writing.
Thank you. We have another question from the floor on the HIPAA waiver. The question is it a blank form that can be presented to any doctor by the person that has been given the permission for access?
So it's gonna have to have, I mean, HIPAA is a group of federal laws, so there's gonna be some language on there specifically referring to, when we say HIPAA, this is what we mean, and these are the certain types of records we want this person to be able to have access to. But somewhere in the form, it has to specifically list that, okay, now these are the people that I want to be able to talk to my doctors, and I have to sign that. So my doctors need to know that I've okayed this, and then that's the form that they would go and present. So if it's just kind of a blank form that says HIPAA on it, it kind of doesn't work.
Thank you. Do we have any other questions that folks have? All right then. Allison, we're coming up at 5 o'clock. Okay, there is another question that just came in. A HIPAA form. Do you file it with the insurer also?
Um, So it has to be the person who's seeking to get your information has to provide it to the person they're trying to get the information from. So whether that's I can proactively sign a HIPAA waiver form and give it to my primary care doctor in advance, or if I'm going into the hospital for a procedure, I'll just present it and bring it with me so they have it. Or I can leave so that way if something happens to me, kind of my providers already have that, so they already know who they can talk to. Or it's I can sign all this paperwork. My husband knows where it is. So if something happens to me, he can just go into the filing cabinet, pull it out, and then he can present it to whomever he's trying to get information from. So it's kind of up to you as to how proactive you want to be, whether you're just kind of in advance providing this authorization to folks. But a lot of times feel more common that it's just kind of letting the people that you've appointed to be able to have that access, the people that you've named on the HIPAA waiver, let them know you've done it, and either just give them a copy of the form, email it to them, and they can hold on to it. Or just say, if something happens to me, I keep it in the top filing, the top drawer of my filing cabinet in my office so they can get access to it if they need it and then can go present it to the people they're talking to.
All right, we have another question. Is a past living will which is carried with me, is it binding?
Yeah, so these documents are legal estate planning documents kind of never, they don't have an expiration date on them. So theoretically, they're good forever, even if it's something you signed 5, 10, 15 years ago. So as long as you have it and it's validly, witnessed, executed, notarized, each state has different rules for specifically what needs to be done. But yeah, if it was valid 10 years ago, it should be valid now. But kind of my one disclaimer is that estate planning documents should be reviewed somewhere in the range of every 3 to 5 years, just to make sure there hasn't been, some law change or to make sure your wishes themselves haven't changed so the right people are identified.
Thank you. Does anybody have any other questions? All right. Well, thank you very much, Allison. All of this information has been very informative, and I know I have some homework to do now that, that you've brought all of this stuff to my attention.
Yeah, and for anybody, if someone has follow-up questions and didn't just want to share them through the chat and have me talk about it in front of everybody today, my contact information is on the slides. So, Joyce, I don't know if you had forwarded the presentation or we can, if somebody wants a copy, we can pass along. All my contact information is on there, so you can reach out to me directly as well.
And I will pass along the presentation to folks, so thank you. All right, we have a great job from one of our participants. So thank you very much, Allison. We appreciate it.
All right, well, thank you for inviting me to speak.
Okay.
Um, yeah, and have a nice, well, at least it's a rainy night here.
Yeah,
So,
it's going to be a rainy night anyway. All right, I'm going to end the meeting for everybody. Thank you so much.